Good morning, everyone. Today we're going to be discussing when and how to conduct a workplace investigation. So before we start out, we want to go through our legal disclaimer. The information in this presentation is intended for informal and informational purposes only and should not be considered legal advice. So you are strongly encouraged to consult your own legal counsel to ensure compliance with applicable law in either your specific state, municipality, or jurisdiction. So the requirement of employers to investigate. Employers have an affirmative duty to investigate in many instances, including civil rights and anti-discrimination laws. So employers must investigate and take prompt remedial action, health and safety laws. Employers must investigate reports of federal or state OSHA violations, and drugs in the workplace laws. So employers with government contracts must investigate reports of workplace drug use. And of course, while an employer has an affirmative duty to investigate in these situations, an employer may just have a general interest in investigating other matters, such as maybe theft or threats of violence as well. And really, failure to take prompt action in response to complaints such as these before us, it could lead to increased exposure of liability if later it's shown that either an act or an omission that caused harm could have been avoided if an investigation had taken place in the workplace. So under California law, a company must immediately undertake effective, thorough, and objective investigation of allegations regarding harassment, bullying, or discrimination. And this kind of goes back to what was formerly known as the Department of Fair Employment and Housing. Now it's the California Civil Rights Department. They have there listed the protected categories in the workplace, and this is the list that includes gender identity, sex, gender, religion, race, color, national origin, and there's plenty more. And so every employer must investigate any work injury as well. So when does an employer have the responsibility for addressing alleged employee policy violations or misconduct? So this could come up in multiple ways. So you hear either when the employer has received a written complaint, when the employer has received a verbal complaint, or where the conduct is open and pervasive to the extent the employer is deemed to have constructive knowledge of the issue. Usually the written and verbal complaints are very easy to spot. Someone either comes up to you, speaks to you, or maybe they send an email letting you know about some type of harassing or discriminatory behavior in the workplace. Where the conduct is open and pervasive, businesses really want to make sure that they're not just thinking of this as, oh, well, this is how this person always is, or this is how the company always does things. We really want to take an eye and make sure that there isn't any harassing or discriminatory behavior occurring in the workplace, even though there hasn't been a complaint brought up about it. And also an important thing to note is verbal complaints are just as important as a written complaint. We shouldn't require employees to express their complaints through a written statement. If someone verbally comes up and gives a complaint, that should be treated in just as high of a regard of the written complaint. So the importance of conducting investigations, it's in the employer's best interest to resolve issues before they have a negative impact on the business. So really, misconduct that goes unaddressed for long periods of time really can affect morale and productivity. A lot of employees who might be on the receiving end of that harassment or discrimination might either be calling in sick, they don't want to show up to work, or maybe they're just not putting in 100% or their full effort into their job. So employers really do have an important interest in protecting the integrity and reputation of their business by conducting thorough investigations. So some essential attributes of investigations. Workplace investigations should have these four elements. They should be impartial, they should be confidential, they should be thorough, and they should be timely. So following these core investigation principles is really essential to an effective investigation that meets an employer's compliance responsibility under the law. So of course, there are instances where employees may come up to HR, their supervisors, and make complaints, but then at the end they may say, oh, but please don't do anything about this, don't follow through with it, don't talk to the accused about it. And sometimes that can be a hard spot for employers to be put in, but really, once an employer becomes aware of the alleged misconduct, harassment, or retaliation, they must take action. So this includes either investigating and taking remedial action to stop any harassing conduct. And it's really not the alleged victim's choice on whether an investigation recurs. It's really the employer's responsibility. You don't want that employee coming forward maybe a year or so later and saying, well, I've made multiple complaints to HR and they never did anything. And it really wouldn't be in the employer's best interest to say, oh, well, they told us not to do anything, because the employer really does have an affirmative duty to take action and to conduct an investigation if they know of any type of harassing, discriminatory, or retaliatory behavior that's occurring in the workplace. So planning the investigation. Once you become aware of the need to conduct an investigation, you must take action. So the first thing you want to do is acknowledge the complaint, and then you want to start to begin planning the investigation. You'll think of who will be the appropriate decision maker, who should do the investigating, and what's the scope of the investigation. So we'll touch on these points in a bit. So who will be the decision maker upon the completion of the fact-finding component of the investigation? So some issues in investigations may be able to be resolved with either an HR professional or managers or business leaders' approval. But then there's some more complicated or higher level investigations, which may require a decision maker at a higher level in the organization. For example, this can include maybe a higher level human resources person on the leadership team and or senior executive. So maybe the employee's direct manager who's accused of some type of harassment, maybe that person's manager doesn't have the authority to maybe terminate them or suspend them, so it needs to go to a higher level of human resources or a higher level of executive leadership. So it's very important to select the right investigator for the investigation. A good investigator should be experienced, they should have received appropriate training, they should be impartial, and they should also be professional. And we really stress these because the investigator could be called to testify if litigation results from the complaint. And he or she that's doing the investigation should be someone who could effectively represent the company as a witness on the stand. So you really want someone who you have in mind that would be a good and reputable witness to conduct the investigation. California law also limits who can perform investigations. So if you're going to stay in-house, you can use company personnel. Sometimes this is an HR person. Maybe you have a specific team or department who handles investigations and complaints when they arise. However, if you want to use a third party, you have to either use attorneys or licensed private investigators to help conduct your investigation. So one thing to consider is, should legal counsel or an outside investigator conduct the investigation? You might be wondering if it's more appropriate to go outside and have a third party conduct it, or if it would be helpful to just have your in-house, maybe HR team conduct the investigation. And you really want to think about some factors involved. So whether there's pending litigation, is there a threat of legal action? Maybe either the complainant or the accused is litigious and you think that it might be best that outside counsel handles the investigation. Another thing to consider is, has the complainant previously pursued legal action or administrative charges, or whether the complainant is an executive or high-level employee. Sometimes when the complainant is a high-level employee or an executive, it might be best to bring in legal counsel or an outside investigator, because maybe someone who's beneath them in terms of hierarchy, maybe HR, might feel uncomfortable doing the investigation and finds that it's best that we bring in outside help to help the employer conduct the investigation. So planning the investigation, a few questions to ask yourself when you're doing the preliminary planning for the investigation. You want to think, what type of investigation is needed? Are other employees involved other than just the accused and the complainant? Are there witnesses to the incident? What additional resources are necessary? Maybe there are some documents that need to be read or some camera footage that needs to be looked over. Again, what potential evidence should be reviewed before conducting interviews? Maybe you should review either the complainant or the accused personnel files to kind of see what's in there before conducting the interviews, and that might help either with the situation or the complaint that's being alleged. Setting the scope of the investigation. Defining the scope of the investigation is really important aspect of the investigation planning. So when you go in to the investigation with a scope that's too narrowly defined, you can often miss important facts and evidence that's right there in front of you. So you might be going into it thinking, oh, this is just for maybe religious discrimination, and you go into it just focusing your questions solely on that. And based on answers and other information you're being provided, it shows that there might be some sexual harassment involved as well. And if you're just so narrowly tailored on the religious discrimination, you might miss those other facts or this whole other issue that's really occurring in your workplace. And it could appear to the complainant, or like I said, if this goes to litigation, could appear as though the employer is just kind of going through the motions and really erodes the confidence in the employer's ability to conduct an investigation. However, of course, on one side of the spectrum is too narrowly defined, and on the other side is too broadly defined. So when it's too broad and we don't really have an idea of what we're going into the investigation thinking about, and we don't have any really topics in mind, it can lead to an unnecessarily lengthy investigation, delayed remedial action, and further disruptions in the workplace. Maybe this behavior is still occurring and we're just going through too many avenues and this behavior still occurs within the workplace. We really want to try and cut the behavior out as soon as possible, get remedial action in there, because like I had mentioned before, these disruptions really could affect workplace productivity and workplace morale. So you want to determine if the individual had knowledge of the implicated policy. Sometimes in organizations, not all policies are in the handbook. Sometimes they're just kind of verbal policies. You really want to make sure that everyone in your organization knows of all of your policies. It's best to have them sign off on policies if you can, and that really becomes helpful if you're doing an investigation and you have to prove that an employee did have knowledge of this business policy that you had in place. You also want to recognize the time commitment it takes to conduct these investigations. Plan and commit to a reasonable investigation timeline. Determine if interim measures are necessary. Maybe a supervisor is harassing an employee. Maybe the supervisor needs to be transferred until the investigation is complete. And participants in the investigation need to be informed. You should let them know that we're conducting an investigation and that they might be called in to give a statement to HR or to the investigator. Another important thing to note is interviews. Where will you conduct the interviews? You should make sure that it's in a private spot where you're not getting a lot of kind of employee onlookers or where employees can pass through. So maybe a closed door office or a meeting room might be best. You also want to think, will you need to interview non-employees or former employees? Some non-employees could be witnesses as well. Maybe you've had a vendor come by and they were a witness to any kind of harassment or discrimination, or maybe volunteers as well. Determine the order of the interviews, and will interviews be either in person, by phone, or online? It's not absolutely necessary that all interviews be in person. I personally prefer in-person interviews. However, they can be by phone or online. You can set up a Zoom meeting, especially now that there's a lot of employees who are working remotely. You still want a chance to get a face-to-face opportunity with that individual who's either a witness, the accused, or the complainant. You might want to do a Zoom meeting if they might be working remotely, rather than calling them into the office if it might not be feasible to do so. So some investigation note-taking practices. You want to start a new page before each interview, so that way your notes don't get mixed up with the previous interview. You want to state the names of those present at the interview, the date, the time, and place of the interview. You also want to put your name on all of your investigation notes as well. You want to document the questions posed and the witness testimony as close to verbatim as possible. I always find it helpful to type out whatever questions I'm going to have maybe the night before, so that way I print out that page and I'm just having to fill in the responses. And of course, there might be follow-up questions that you ask. Just be sure to try and write the follow-up question in your notes as well, and the answer. You really want to focus on the facts. You don't want to make any assumptions. If it's in-house, you might already know the people involved. So you really just want to try and be impartial, just focus on the facts. And you want to make note of any issues raised and any new witnesses identified. It's also very important to note any inconsistencies. This is going to be really important towards the end when you're either doing follow-up interviews with people who you might have already interviewed previously, and you're trying to reach a conclusion or determination. You also want to review the key points in your notes with the witness to confirm accuracy. And you always want to ask afterward if the witness has anything else to add. It might be something that you didn't bring up that they've wanted to mention, and that's their opportunity to do so. You want to review and finalize your notes immediately after completing the interview, so everything's still fresh in your mind. Make sure your interview investigation notes don't have obvious grammatical errors and misspellings. And you might want to keep a separate document to record any comments on witness demeanor. So this could include eye contact. Maybe they were making eye contact with you through the interview and you felt that made them less credible. Maybe their body language was defensive or evasive. You can also note maybe emotions, their tone of voice maybe showed anger or they were crying. Different things like that might be helpful to also include in a separate document. So these are just some standard basic workplace investigation questions. Of course, all investigations will be different. You might add in questions that are more specific to the situation at hand. But some very basic ones that you'll want to have answered are when, where, and what occurred, who was present, what happened before the incident, kind of what led up to the incident. Who have you spoken with about the incident? Did you indicate that you were offended, or did you ask for the conduct to stop? This plays more into maybe like harassment, discriminatory, and retaliatory investigations. So when you're conducting the interview and opening the interview with the complainant, you want to make sure that you communicate that the organization takes claims of wrongdoing very seriously. You really want to convey that they're being heard and the employer is going to take this seriously. No complaint is too small. You do want to let them know that the company will investigate thoroughly, that they'll keep the information as confidential as possible. Sometimes HR has to communicate with a supervisor or maybe the CEO, the owner of the company. Also, you want to let them know that you'll take whatever action is appropriate given your findings. You also want to communicate that the complainant is responsible for being honest and providing all pertinent information. And another very important thing that you want to do is you want to put them at ease. So you want to let them know that no conclusions have been made, but inform them that retaliation is prohibited. They might be nervous to come forth with a complaint because they think, especially if it's someone who they're accusing might be a supervisor or in some position of authority, they might be nervous that that person is going to retaliate against them, maybe with shorter hours or disciplinary notices. And you really want to let them know that they should be honest with you and that retaliation is prohibited, and really just putting them at ease. So when you're opening the interview with your witnesses, it's important to thank them for their time, their cooperation. You want to let them know that the purpose of the meeting is to investigate complaints of workplace misconduct, and let them know that they've been identified as someone who may have information that could be helpful to the investigation. You also want to let them know that retaliation from anyone related to their participation in the investigation is prohibited. Just like you're putting that complainant at ease, you also want to do the same thing for witnesses. It's very important that they're honest and provide you with all pertinent information as well, something to remind them. But also they might be nervous to bring about their account of what happened because they might also be scared of retaliatory measures. You also want to request and speak to them about the importance of confidentiality. You want to let them know that anything that's said during the interview, that you hope that they keep it confidential as well. You don't want one witness to kind of poison other witness statements if they go and chat about the investigation or questions asked or how they answered later on after the investigation takes place. When you're conducting the investigation with the accused, same thing, you want to thank them for meeting with you, thank them for being cooperative. Let them know that the purpose of the meeting is really to ask about allegations of workplace misconduct made against them. And also want to let them know that you're going to keep the information as confidential as possible. Like I mentioned before, you want to keep the information as confidential as possible, but share it on a need-to-know basis. You want to let them know that you'll take whatever action is appropriate, but that no determination about what occurred will be made until all the information has been collected. You really want to stress that this isn't an attack on them, as they might take it that way and they might be defensive. You really want them to be open and explain their side of the story. Let them know that right now we're in the process of fact-finding, gathering information, so anything that they can provide is really helpful. And that might give them the chance to open up a bit more if they understand that we're really just trying to gather information at this point. You also want to let them know that any form of retaliation is strictly prohibited. Like I mentioned, if they're in a supervisory position, management position, it's very important that you stress that. because you might be saying, well, you might be giving names of the complainant, of the witnesses, and it's very important for you to let the accused know that retaliation is prohibited, because then that opens up another investigation. And you also want to speak to them about the importance of confidentiality. You don't want them going and telling other people who you might call in for witness interviews that they're saying, oh, well, this person's accusing me of all of these falsehoods and things like that. You want to make sure that you tell them that it should be kept confidential as well, and they shouldn't speak to others about the investigation. So with all participants, you always want to ask at the end if there's anything else that they would like to add. Like I mentioned, one of your questions might not have been directed towards a comment they'd like to make, or maybe some other evidence that they want to bring forth. You want to acknowledge them for their appreciation, or I'm sorry, for their cooperation. Let them know that you appreciate that they took their time to help out with the workplace investigation. You also want to give the participant your contact information and encourage them to contact you with any additional information related to the investigation. Sometimes people don't think of things on the spot. They might remember something that happened maybe an hour or so after you did the interview, and it comes to them and they might have more details. It's important that you leave your contact information, or a contact, if it's a third party, a contact at the company who can give you, who can give that witness or the complainant, whoever it may be, the third party's contact information so they can provide additional information related to the investigation. You also want to remind the participants of the seriousness of the matter and the importance and purpose of the confidentiality, which avoids further harm and assures objectivity from everyone who will be interviewed in the investigation. Also, remind the participants of the non-retaliation requirement. Remind everyone that retaliation is strictly prohibited, and if they see any signs of retaliation, to immediately report it to HR or to their supervisor, whoever's the appropriate contact in that situation. So some things that you do not want to do when questioning employees in workplace investigations is you don't want to imply bias. You don't want to say, oh, well, we know you wouldn't do this. We just need your help to show that you wouldn't. Or, I know this sounds ridiculous, but did you see Marcy in the coat closet with Nick? You don't want to pose any questions like that where you're kind of implanting your own opinion into the mind of the witness. You really want to leave it as objective, as impartial as possible, and really just ask open questions. You don't want to put your opinion in it at all. You also don't want to use leading questions, and you don't want to put words in the witness's mouth. You want to ask very open-ended questions so the witness or the complainant or the accused can give you as much information as possible and gives you a lot to work with when you're looking over your investigation notes and drafting your investigation report. Re-interviewing participants for clarification. This can come up pretty often. So maybe you interview the complainant first, and then throughout some witness statements, you realize that there's something that doesn't quite make sense, and you're going to have to go back to the complainant or go back to a different witness. So they often do require clarification and follow-up when there's either new or contradictory information that's been provided. And re-interviewing the complainant, the accused, and or witnesses is appropriate in instances such as those mentioned. So clarification interviews, it allows the investigator to address questions related to some new information. Follow-up interviews need to be conducted in the same manner and with the same formality as initial interviews. So you're still going to want to mark the time and the date. You want to keep that on a separate piece of paper as well, so it clearly denotes when the first interview started and when the follow-up interview began. Statements on confidentiality and prohibitions against retaliation should also be made at the start of any follow-up interviews as well. So some things to consider when you're evaluating whether a violation has occurred. You want to think back to this person's, either the witness, the accused, the complainant. Think about their credibility, their demeanor, their memory, bias, cooperation, consistency of the accounts of the events, and review any action taken in the past. Maybe the accused has disciplinary notices in their personnel file that show that they've done this same or similar behavior that the complainant is accusing of them now. Maybe they've done this in the past. It's really important to look at things like that when deciding when a violation has occurred. You want to think, is there evidence of truth to the allegation? Either how could the alleged misconduct occur, or how could it not occur? Are there any trends in the results? Maybe there's similar people complaining of similar instances of harassment, discrimination, or misconduct. And then are multiple witnesses supporting one version of the facts over another? So reaching a conclusion, the investigation's decision maker must reach a conclusion at the end of the investigation process. It's really important when arriving at a conclusion, the investigator or the decision maker needs to consider the following questions. So was the complaint substantiated or not by the evidence? And was the evidence obtained in the investigation inconclusive as to whether the alleged conduct took place? And that's really when you're going to go back, look at witness statements, if there are any, look at your evidence, whether it be camera footage, any documentation, maybe computer files, anything that can help you either show that the complaint is either substantiated or not substantiated at this time. So when you're drafting your investigative report, it should include the original complaint. You want to describe the original complaint. You also want to describe the nature of the alleged policy violation or conduct. Maybe you have a policy, your policy against harassment. You want to describe that policy within the investigative report. You want to show whom you spoke with and when. So you don't really need to include a timeline. A timeline might be helpful for you if you look back to the report, or if you want to include the dates and times of everyone you spoke with by their name when you draft up their summary of the interview that took place. And then maybe you can put it in chronological order so it's easier for you to tell when you spoke to these individuals. You want to cite any applicable provisions, either in law or, again, policy provisions. Include copies of and references to any documents reviewed in the investigation. I like to include any documents that I've reviewed at the end of the investigation and type up at the beginning just kind of the titles of the documents I reviewed, and then I include the actual documents toward the end. So that way everything is in one place with the investigation report if it ever needs to be looked at a later time. You want to provide an assessment of the credibility of the evidence. You also want to document the investigation conclusion with an explanation for the conclusion that was reached. You don't just want to jump right into the conclusion, but you want to provide some analysis in there too. Maybe the complainant has a motive for bringing false allegations against the accused. You want to put that analysis in there as well. Whatever you find very important and how that helps you make your determination, you'll want to include that in the report. If the claim is not substantiated, the investigation summary must clearly document why. So maybe it's a he said, she said, and unfortunately we don't have any audio or camera footage or no witnesses. That's a time where the claim might not be substantiated, and that you should thoroughly document why in there as well. So you also want to recommend appropriate action be taken if necessary, and the proposed action must stop any misconduct or inappropriate behavior. So, like I mentioned, really determining the appropriate remedial action is a very important aspect to the investigation, because the remedial action must stop the offending behavior and prevent the misconduct from reoccurring. So depending on the nature of the misconduct, there is a range of actions that can be appropriate. And of course, you look at the severity, frequency, and really just to decide what remedial action may be appropriate in that circumstance. At the most severe end, an employee may be terminated for misconduct, but there's many things that an employer can do before that if it doesn't rise to the level of termination. So some examples of some potential remedial action include maybe assigning additional training or retraining. So maybe some sexual harassment training might do the employee good, or workplace civility, racial discrimination training, or maybe just management training. Maybe it's just a manager and an employee, and you find that there's a communication issue there, and you think that the manager might be a good candidate for some additional management training. Maybe suspension, reassignment, reviewing and distributing policies. So maybe they really need to take a look at your workplace policy again, might want to redistribute that to them, sit down with them while they review it, have them sign off on it. Also, maybe restructuring of the workplace or reporting relationships might be helpful as well. Transfers, verbal or written warnings, demotions, and like I mentioned before, if it's something that's severe or frequent, that could also lead to termination given the circumstances. So communicating the investigation findings, when you meet with the accused, you want to describe the course of the investigation and results. You want to inform the accused of any disciplinary action that will be taken, and anticipate questions including who to contact if he or she doesn't agree with the findings. So you definitely want to give them the opportunity to maybe contact the investigator or maybe the decision maker, again, because maybe there's something that they may have remembered that they didn't remember during their interview that they want to provide as well. And you just really want to leave that line of communication open. You also want to remind the accused that retaliation will not be tolerated. When you're meeting with the complainant, you want to describe the course of the investigation and the results. You want to confirm that appropriate action has been taken and remind them that retaliation will not be tolerated, and encourage the complainant to contact you with any future concerns. So they might contact you with a future concern of retaliation, and you want to make sure that they feel comfortable enough to bring that up and to do so. When you're creating your investigation file, there should be certain documents that you include and complete in your investigation process. And this should be your investigation plan, your investigation notes, any interview notes, and any written statements from the participants, notations of communication, of confidentiality, and retaliation reminders to participants. I find that it's easier to remember to disclose the confidentiality and retaliation reminders if I have it on my actual list of questions that I go in there with either the complainant, accused, or witnesses. I have a little portion that reads confidentiality and another one that reads retaliation, so I can check off, and I know in my mind that I mentioned that to all of those involved in the investigation process. You also want to have copies or lists of any documents reviewed. Any interim actions taken, maybe during the time that you were conducting the investigation, you had transferred responsibilities and assignments of the accused to someone else. You also want to have the investigative report in the investigation file as well. So at the conclusion of the workplace investigation, the findings need to be documented and the investigation file should be closed. You want to provide notices to the accused and to the complainant. So a notice to the accused reflecting the results of the investigation and any disciplinary action. And if the investigation results in discipline, then a notice should go in the personnel file and any notice really regarding any discipline for the accused should go in the accused personnel file, so that way others can look back to it if a similar situation occurs. A notice to the complainant. This notice shouldn't be included in the complainant's personnel file, but you can give them notice that the workplace investigation finding is completed and the file is closed. So the investigation file should also be kept separate from personnel files. It shouldn't be included in the same personnel files. It should be in their own file, and it should be clearly marked as an investigation file. So even after the investigation summary report has been completed, appropriate remedial actions have been taken, employers still have various follow-up activities to complete. So some follow-up steps include taking measures to ensure there is no retaliation, ensuring any appropriate discipline is actually imposed, followed through, and carried out on, checking in with the complainant on a periodic basis. This helps. They might be too nervous to complain if there's maybe retaliation. So doing a periodic check-in to see if the behavior has stopped and to ensure that there hasn't been any retaliation does really help the employer. And reviewing and auditing internal operations. Maybe through this investigation, you realize that an internal operation could have maybe avoided this workplace harassment or conduct, and it's important to review and audit what the company could have done. So important things to know, employers should have policies related to resolving workplace complaints. Employers should also have policies covering anti-harassment, anti-discrimination, and anti-retaliation. Employer policies should clearly state the requirement of participation in any investigations. Employer policies should also establish and communicate a complaint reporting process that is accessible to all employees. And really what I find to be very important as well is employees should have alternatives to whom to report harassment. Like I had mentioned, it could be their direct supervisor that's exhibiting this harassing behavior, and it's very important that the employee doesn't just have that one line of communication to put in their complaints, but has other avenues as well, such as maybe HR or another department supervisor. They should be able to come to them as well with reports of harassment. So some final thoughts, employers must not do the following. So employers really do not want to ignore complaints. No matter how small or trivial they might be, you still should make an effort to follow up and to investigate complaints. Select an investigator who is biased or perceived as biased. You really want an impartial and objective investigator. And sometimes you might realize that no one on the team or in the company can truly be objective. So that's probably when it's best time to go to a third party outside counsel. An employer must not fail to be objective. Like I mentioned, this is very important. You really want to maintain objectivity throughout the entire investigation. Failing to maintain confidentiality, you want everything to remain confidential so that way it doesn't hurt or harm any other witness statements, because you want the witnesses to remain as objective as possible as well and give you a straight account of what they witnessed happening. You don't want to delay the investigation. This could cause the misconduct to go on for a longer period of time than needed, and that could really slow down workplace productivity or hurt workplace morale. You don't want to fail to speak with witnesses provided by the complainant or the accused. You want to speak to as many witnesses as you feel would best help your investigation, and you don't want to ignore any of the witnesses that the complainant or the accused brings about, because they might have some good information that'll help. You don't want to fail to protect the complainant and witnesses from retaliation, because then that opens up the company to even more liability. You also don't want to fail to take corrective action or impose discipline where appropriate. Some important things to remember are there's no single way to perform a workplace investigation. It really does vary based on circumstances and what the investigation even entails. There are best practices and essentials that must be followed, but really different situations may call for different approaches. The guidelines discussed should be viewed as flexible. Of course, different investigations call for different questions, maybe different witnesses, maybe some you're involving former employees or non-employees, as I mentioned before. It really is different, and you should really be flexible with your approach to all the investigations. You want to keep the essential investigation tenets, so impartiality, confidentiality, thoroughness, and timeliness. Always keep those 4 elements in mind when you are conducting an investigation. You also really want to thoroughly document the investigation from beginning to end. You'll really find that at the end, when you're trying to come up with your conclusion or really analyze your findings, it's very important that your documentation and your notes be thorough, so you have a good base to kind of base your conclusions and your findings upon. So that's about it. Thank you for joining our webinar. And I also just want to mention that our next webinar, November 17th on Thursday, we will be discussing new laws for 2023 and employer compliance. There's going to be a lot of new laws that take effect into 2023 that will affect small employers as well as large employers. So that'll be a good webinar to catch as well.
Awesome. Thank you so much, Kayla. We got a couple questions here in the chat. If anybody else has any more questions, go ahead and type those out. Our first question here says, you say to determine if the individual had knowledge of a particular policy, each employee receives a handbook and signs that they have received it. Do we require that they prove they've read it?
No, so really when they sign that handbook the employee handbook acknowledgement, they're stating that they have read it and they understand it. But I would make sure as the employer, you're giving them adequate time to review the employee handbook. You don't want to give them the employee handbook and then expect it back in 10 minutes and say, okay, you have 10 minutes to sign this handbook, because oftentimes employee handbooks are longer than 50 pages. You really want to give them adequate amount of time to read through it. And then that all helps the employer show that the employee should have known about the policy. They signed off stating that they've read and understood it. They had the opportunity to ask questions and they never did. And that you gave them an adequate amount of time to review it.
Is it okay to audio record interviews with the participants' knowledge and consent to ensure you capture accurate notes?
You can audio record the interviews. So just make sure that everyone in the room understands that it's being audio recorded. This might make some participants uncomfortable. So yeah, definitely make sure that you have their knowledge and consent. I would highly recommend getting written consent from everyone who's in the room who you plan on recording or having audio recording. Even if it's just someone who's kind of like HR or anyone else, you definitely want to make sure that you have their written consent for the audio recording.
I own the company and am supposed to be impartial. At what point do I say this isn't the thing for me to be doing and I need to reach out to my CalWork safety person to do this?
Yeah, so if you find that you might not be impartial, because of course it's hard if you're the owner of the company, you might know some employees longer than others, you might have different relationships with certain employees where you feel like maybe you won't be impartial, maybe it's hard for you to be objective, which is better to say that and understand that you'll be impartial. You might have biases and go to your CalWork Safety and HR consultant to help you out. We'll be there for you if you want us to sit in on the interviews, if you want us to conduct the interviews, help writing the report. But whenever you even have an inkling that you might feel like you have a bias or you might not be fully impartial, it's great to reach out to CalWork Safety and HR and have a consultant help you with the investigation.
Let's see here. Can you please show the last slide, the conclusion?
Yes. Is it this one?
I believe so.
Okay.
Is it okay to name the complainant when interviewing the accused?
Yeah, it's okay to name the complainant, and sometimes it's necessary, especially if it's something where it was just two individuals involved. And I think sometimes the complainant might be nervous to bring forth their complaint, and you kind of have to let them know, well, in order to really accurately interview the accused, sometimes we're going to have to give your name out. Because oftentimes there aren't any witnesses, so we can't say, oh, these multiple people witnessed this type of behavior or these actions. So I think it's important to tell the complainant that retaliation is strictly prohibited, so they feel more comfortable freely expressing their complaint and don't feel nervous to have the company mention their name to the accused when interviewing the accused. Sometimes it's important for the accused to know who's making the complaint so they have an idea of the situation that's being brought up or alleged.
All right, looks like our last question here. Should we change the process and hand them the handbook, then say, once you've read it, bring back the signed acknowledgement?
You can do that, or you can give them maybe an hour or two to complete their new hire documents, or maybe if you're doing an employment handbook update, you can give them time just to show that you've given them necessary time to review it and to read it, and you can follow up, ask them if they've had any questions on it, maybe give them an hour and a half, come back to them, ask them if they have any questions, or you can sit down and review it with them. There might be some policies that you might want to highlight a little more than others. So for instance, your anti-harassment, anti-discrimination, and anti-retaliation policy. Maybe you want to highlight that a little more than some of the other things like paid holidays or something like that. So you can always sit down with them, go over the very important policies with them, so that way you understand that they've read it, they understand it, and you have a better idea that they've signed the acknowledgement, knowing that they've read through your important policies.
All right. Do we have any more questions? All right, great. Thank you again for sharing. This is an important topic. Remember, if we didn't address your question today, go ahead and reach out to us at info@calworksafetyhr.com. Again, be on the lookout for future topics on our website at calworksafety.com. Thank you for joining us. Have a wonderful rest of your day.